A renter in Mississauga signs a 1-year lease in September. It was the start of a new chapter. By February, her company transfers her to Calgary. An unexpected shift. She calls her landlord. A call that would change everything. The landlord tells her she owes every remaining month of rent. 8 months. The debt is overwhelming. At $2,200 a month. That is $17,600. She pays it. Every single dollar. It was a massive financial blow. Because nobody told her about Section 95, the key to unlocking the problem. Before we get into how to break one, you need to understand what a residential lease actually is in this country. Because the document your landlord handed you is not what most tenants think it is. It is not a jail sentence. It is not a financial trap you cannot escape. And it is not, under any provincial tenancy law in Canada, the final word on what you owe. The real law is bigger than your lease. A residential lease in Canada is a contract, and like every contract, it exists inside a legal framework that overrides it. The weight of the law is absolute. That framework is provincial residential tenancy legislation, and every single province has it. A national legal standard. Ontario has the Residential Tenancies Act, 2006. British Columbia has the Residential Tenancy Act. Alberta has the Residential Tenancies Act. Quebec has the Civil Code of Quebec and the Act respecting the rental of residential and movable. Nova Scotia, New Brunswick, Manitoba, Saskatchewan. Every province has a version of this legislation, a coast-to-coast protection. Here is what that legislation does. It sets a floor, a minimum standard of rights that no lease agreement, no landlord, and no legal-sounding clause printed in bold on page 4 of a standard form can take away from you. It cannot be enforced. Your landlord knows this. Most tenants do not. That information gap is costing Canadian renters hundreds of millions of dollars every year. There is a provision sitting inside the Ontario Residential Tenancies Act that most tenants have never read. Section 95 of the Residential Tenancies Act. Here is what it says, stripped of the legal language. A tenant can assign their lease to another person. With the landlord's consent, the landlord may refuse. They might try to block your path, but you have options. But if the landlord refuses without a legitimate reason, meaning a reason the law actually recognizes, the tenant has the right to terminate the tenancy. Read that again. You are free to walk away. If your landlord says no to an assignment without a legitimate legal reason, you can walk out the door. Without penalty, without owing the remaining months, without it going to collections. You serve notice under Section 96. 60 days, and you are done. This is not a loophole. This is the law. It has been the law since 2006, and the reason most tenants do not know about it is simple. The landlord never tells you. The leasing agent never tells you. The rental office never puts a poster on the wall, because the moment you know about Section 95, the leverage shifts. Let me walk you through this exactly because the process matters. Step 1. You want to leave before your lease ends. You write to your landlord in writing. Email is fine, but keep a copy. This is your evidence. You write to your landlord in writing. Email is fine, but keep a copy. This is your evidence. You do not need to have a replacement tenant in hand when you ask. You ask first. The space is still yours for now. Step 2. The landlord has a decision to make. They can agree. They can refuse, but allow you to sublet instead. Or they can refuse outright. Step 3. If the landlord refuses outright, you now have something. Under Section 96 of the Ontario RTA, you can give 60 days written notice to terminate. If your tenancy is monthly, the termination date must fall on the last day of a rental period. Watch the days count down. That is it. That is the exit. The landlord cannot sue you for the remaining months. Not legally. Not under the framework that governs this transaction. The foundation of Canadian law remains firm. Now, a legitimate refusal. What does that look like? The landlord can refuse to consent to a specific proposed assignee if they have a legitimate reason related to that person. A reasonable concern about whether that person can pay. A reasonable concern based on a credit check. What the landlord cannot do is refuse all assignments categorically. Refuse because they do not want to deal with it. This is an overreach. Refuse because they want you to keep paying. That is not a legitimate reason under the Act. It will not stand up in court. And if that is what they give you, the 60-day termination clock starts. This is where it gets important. Because tenancy law in Canada is provincial, and the rules are non-identical everywhere. Ontario, Section 95 and 96 of the Residential Tenancies Act. Assignment right exists. Landlord refusal triggers 60-day termination right. Fixed-term leases automatically convert to month at the end of the term. A tenant on a converted month-to-month lease can leave with 60 days' notice ending on the last day of a rent period. Putting it in writing is essential. No landlord consent required. This is the one Ontario tenants miss most often. You have the power to move on. Your fixed-term lease ended. You stayed. You are now month-to-month. You can leave with 60 days' notice. The landlord cannot hold you to another year. Breaking the chains of an unfair renewal. British Columbia. Section 34 of the Residential Tenancy Act. Tenant can assign or sublet with landlord consent. Landlord cannot unreasonably withhold consent. If landlord refuses unreasonably, tenant can apply to the Residential Tenancy Branch for dispute resolution. Fixed-term leases in BC have been a different story. Until 2021, a fixed-term lease could force tenants to stay or pay. That changed forever. Landlords in BC can no longer require a vacate clause at the end of a fixed term unless they or a close family member genuinely intends to move in. A significant victory. Alberta. The Alberta Residential Tenancies Act works differently on one key point. There is no automatic right to terminate the lease if the landlord refuses an assignment. You can feel stuck in place. What Alberta does have is a requirement for the landlord to mitigate damages. This is important. If you leave early in Alberta, the landlord cannot simply sit there and collect rent from you for 6 months while leaving the unit empty. They have a legal obligation to make reasonable efforts to re-rent the unit. If they re-rent it, your obligation ends. If they refuse to advertise, refuse to show it, refuse to accept a reasonable applicant, their damages claim against you shrinks accordingly. A landlord who does nothing and sends you a bill for 6 months of rent is not going to win that case if you can show they made no effort. Discard the unfair demand. The framework is more tenant protective than most Canadians realize. A tenant in Quebec can transfer their lease. The landlord can refuse. But if the landlord refuses unreasonably, the tenant can apply to the Tribunal Administratif du Logement for authorization to transfer. The TL can grant that authorization over the landlord's objection. Also relevant in Quebec. A lease in Quebec renews automatically at the end of the term. The cycle repeats. The landlord must give notice if they want to change the conditions. It must be a formal, written notice. A lot of Quebec landlords get this wrong. When they do, the lease renewal rules protect the tenant. Manitoba. The Residential Tenancies Act of Manitoba. Similar assignment rights. The Residential Tenancies Branch handles disputes. Landlord must not unreasonably withhold consent to assignment. Taking action in Manitoba. Saskatchewan. The Residential Tenancies Act, 2006. Assignment with landlord consent. Disputes go to the Office of Residential Tenancies. Nova Scotia. Residential Tenancies Act. Assignment right exists. The Director of Residential Tenancies handles disputes. Across the Atlantic coast, there is a provision inside the Ontario Residential Tenancies Act that most Canadians have never heard of, and it is one of the most important tenant protections in the legislation. Section 47.3. A tenant who has experienced domestic violence, sexual violence, or stalking can terminate a tenancy with 28 days written notice. A vital safety net. 28 days, not 60, not 90. You do not need to wait for the end of a lease term. You do not need the landlord's permission. You do not owe the remaining months. You serve a notice. You attach the required documentation. You leave in 28 days. The required documentation is a statement signed by a physician, nurse practitioner, registered nurse, or psychologist, social worker, or lawyer, or a signed statement from a prescribed organization, a shelter, a domestic violence support organization. The landlord cannot contest this notice. The landlord cannot ask for more information. British Columbia has similar provisions under Section 45.1. Manitoba, Saskatchewan, Nova Scotia, and New Brunswick have equivalent protections. Across all provinces, if you are in this situation, or someone you know is, this provision exists. Most people who need it have never been told about it. Share the knowledge. Here is the one nobody expects. If your landlord is failing to maintain the unit, you have potential grounds to terminate. Section 29 of the Ontario RTA gives a tenant the right to apply to the Landlord and Tenant Board for a rent abatement or termination. Under Ontario law, a landlord must maintain a rental unit at a minimum temperature of 20 degrees Celsius from September 1st to June 15th. Water damage that is not repaired, pest infestation that is not addressed, A broken heating system in February. These are not just inconveniences. They are breaches of the landlord's obligations under the Act. Document everything. Date stamp everything. Send written notice to the landlord by email or registered mail. Build your evidence. If they do not, that paper trail is your foundation at the landlord and tenant board. I want to spend some time on this because the misinformation around lease breaking in Canada is expensive. Myth 1. You owe every remaining month of rent if you leave early. You do not. Not automatically. Don't be misled by the bill. The landlord has a duty to mitigate. They are legally required to make reasonable efforts to find a new tenant. Myth 2. Breaking your lease will ruin your credit. A lease itself is not reported to the credit bureaus. What can affect your credit is a debt sent to collections. If the landlord wins an order and it goes unpaid. A specific legal sequence. Myth 3. A fixed-term lease locks you in for the full term no matter what. Already addressed this. Break the cycle of misinformation. In Ontario, if you are past the end of your fixed term, you are month to month. You can leave with 60 days notice. Myth 4. You need to find your own replacement tenant or you owe the rent. This is partially true in some situations, but the landlord's duty to mitigate means they cannot simply refuse to look for a new tenant and then bill you for the vacancy. They must act. Myth 5. Verbal agreements with your landlord protect you. They do not. Every agreement must be in writing. Don't let it fade away. Use the official provincial forms. In Ontario, a mutual agreement to end a tenancy is Form N11. Without it, the agreement doesn't exist. Let me give you this clearly. Step 1. Know your tenancy type. Are you in a fixed term? Are you month to month? Knowledge starts here. Step 2. Document your situation. Job transfer, illness, or maintenance failure. Document it for the process. Capture the proof. Step 3. Write to your landlord in writing. Email, not a text. State clearly what you are requesting. Section 95 language matters. Step 4. Use the official forms. Form N9 is the notice to terminate. Form N11 is the mutual agreement. Download the right tools. Step 5. Know your timelines. Ontario requires 60 days notice ending on the last day of a rental period. Do the math carefully. Step 6. Follow through. Hand back the keys. Take time-stamped photos of the unit on the day you leave. Every room, every surface. This happens a lot. The landlord responds with legal threats. Most are legally incorrect or meaningless. Don't panic. Contact the tenant rights organization in your province. Ontario Community Legal Clinics, BC TREC, Alberta CPLE, Quebec RECLAUC. Help is available. These organizations are free. They handle these calls regularly. They know the legislation your landlord is counting on you not knowing. Let me close with the numbers. Average urban rent is $1,800 to $3,200. Toronto crosses $2,500. Vancouver crosses $2,800. The cost of living is rising. Handing over $15,000 you didn't legally owe is a knowledge deficit dressed up as a legal obligation. Turn the page to empowerment. The information that protects you exists. Share this video. Send it to the person who feels stuck. They are not stuck. Spread the word. Most of the time, they just have not read Section 95.